In case I forget to mention it when we rise at 4, we'll be rising at 3 tomorrow. If that leads to problems, and I hope it won't, but if it leads to problems, we can trickle over into Thursday. I hope that's not inconvenient to anybody.
Well, thank you very much.
Thank you.
My Lord, can I start with giving my Lord Sumption the reference from the Empire of Iran case on the recognition in that case that diplomatic immunity could extend further than state immunity. The case is at A11 tab 115.
Thank you.
And the relevant references are page 59, MS 4517, and page 75, MS 4533. Just in very brief terms, that case, as you may have seen from the brief look we had at it earlier, involved an attempt by the German government in intervening in proceedings relating to a repair contract relating to the Iranian embassy in Germany. An attempt by the German government to contend that immunity should apply to a claim of that nature by reference, amongst other matters, to their assertions as to the state of diplomatic immunity. And it was said by the government that in the context of diplomatic immunity, to allow a claim of that kind to go forward might impair the diplomatic function if made against a diplomat. We get that from page 59 of the judgment, MS 4517, by a little letter C on page 59. We then get the rejection of that argument and the material passage that I was referring to on page 75, MS 4533, where it said, contrary to the view of the Federal Minister of Justice, one cannot determine the extent of state immunity from Article 31(1)(a) of the Vienna Convention. And then the last 4 lines in particular of that paragraph, the extent of this immunity differs from that of state immunity. It extends further. In principle, therefore, the extent of state immunity cannot be determined from that of diplomatic immunity. And on the facts in that case, the German court had no difficulty, as one sees from page 81, in concluding that a contract for repair didn't in any way impinge upon sovereign functions, and so immunity was not permitted. Going then back to where I was in my submissions and the help that one gets from the remainder of the Vienna Convention on diplomatic relations as to the meaning to apply to the term commercial activity in Article 31(1)(c. The last of the provisions relied upon by the Court of Appeal, and the one I hadn't yet addressed in any detail, is Article 42, which you find at MS 1000 and back in tab 1, bundle 1, tab 2.
Yep. Is Article 42 included in the schedule of articles to the Act, Mr. Ross?
My Lord, no.
Why would that be? Why would that not be, rather?
I don't know, I'm afraid, my Lord. I have to think about that answer, if I may. It was conceded in prop end, as we'll see, that notwithstanding that, it was permissible, given the wording of the Vienna Convention on the Law of Treaties, to have regard to provisions which hadn't strictly been scheduled to the Act. And I would make the same concession. I wouldn't seek to resist this court looking at the entirety of the Vienna Convention on diplomatic relations for the purposes of reaching a view on what Article 31(1)(c) means. We'll look and see if we can find any specific explanation as to why it was not included. As I said earlier, this article, of course, featured both in prop end and in the Court of Appeal's judgment heavily. The Court of Appeal addresses prop end at paragraphs 11 to 12 and at 17, we've addressed it in our printed case at paragraphs 31 to 35 and 50. And the simple and primary argument we make is that even if the reasoning in prop end is fully accepted, and therefore the wording of Article 42 requires there to be a personal profit element to any form of activity before it can fall within the Article 31(1)(c) exception, then we say that personal profit element is present in a case concerned with human trafficking, where the employer is a perpetrator of that trafficking and yielding a specific financial gain as a result. Our more far-reaching argument, it's perhaps wrong logically to characterize them as primary or secondary, but our more far-reaching argument is that, if necessary, we say prop end should not be followed. And whilst Articles 42 and Article 31(1)(c) may be treated as interrelated, the fact is they use different wording, and the terms of Article 42 should not be taken as defining the four walls of the commercial activity exception in Article 31(1)(c). It would certainly be the case that conduct which breached the prohibition in Article 42 would be within commercial activity, falling outside official functions. But it need not be the case that that be the full reach of the commercial activity exception. So the prop end decision itself is at tab 5 of bundle A1, MS 1150. And we've again sought to summarize the facts and the key findings in our printed case from paragraph 31 onwards. The case concerned a very different factual background to the present one. It involved the question whether, in particular, a Superintendent Singh, a police liaison officer and diplomatic agent, accredited as a diplomatic agent at the Australian High Commission, could be held liable for contempt as a result of his alleged breach of an undertaking given to the High Court pending a challenge to a search warrant obtained by the Metropolitan Police, which had itself followed a request for mutual assistance made by the Australian government. And Mr. Justice Laws held that Mr. Singh was entitled to immunity pursuant to Article 31 of the Vienna Convention, and that the exception from immunity relating to professional activity did not apply. Having set out the factual history, he turned to the issues of law at page 628 of his judgment, MS 1167.
Yep.
At 629 to 630, he set out the material provisions of the schedule to the Diplomatic Privileges Act, including Article 31. At 632 to 633, he then set out what he described as, on 632, as the juridical setting in which the Diplomatic Privileges Act and the State Immunity Act had effect. And importantly, we say, for the way we put our argument, at 633, Mr. Justice Laws held that the divide between acts done iurae imperii and acts done iurae gestionis, at the heart of the restrictive doctrine of state immunity, also underlay the exceptions to diplomatic immunity, constituted by subparagraphs A to C of Article 31(1) of the Vienna Convention.
Yep.
He then set out the recital, the preamble to the Vienna Convention, and concluded at 633 that the law relating to diplomatic immunity is not freestanding, this is towards the foot of the page, from the law of sovereign or state immunity, but an aspect of it. At 634, he accepted that the circumstances in which state and diplomatic immunity might be lost might not be coterminous, but he repeated his view, just about halfway down, of their interrelationship in principle, notwithstanding that. So far as Article 42 specifically is concerned, he considered this page 635, and he records there the concession that Mr. Plemming made, which I've just referred to in my answer to my Lord Wilson, as to the legitimacy of at least looking at Article 42. And he sets out the argument of the plaintiffs that Mr. Singh had been engaging in professional activity within Article 31(1)(c) as a police officer. And he rejected that argument, saying he had no hesitation in holding that the phrase professional or commercial activity refers to activity which might be carried on by the diplomat on his own account for profit. At 636, he went on to hold that Mr. Singh was plainly not so engaged, and he plainly wasn't. He was acting in his policing capacity. And so Article 31(1)(c) exception therein could not apply. Now we say again, quite simply, that this approach and analysis, even accepted in its full breadth, presents no barrier to Miss Reyes succeeding on this appeal. As we've sought to explain in paragraphs 34 and 50 of our printed case, her position is that even accepting a profit element is to be read into Article 31(1)(c), it can and should be held to be present here, where the employment contract entered into is of the commercially exploitative nature of the present one on her case. Her alternative submission, albeit that it is more far-reaching, as I've submitted and acknowledged, is that the approach at Prop End of treating Article 42 and Article 31(1)(c) not just as related, but as effectively coterminous, should not be followed for two reasons. Firstly, it would create what we submit to be an unprincipled divergence of approach as between state and diplomatic immunity. And secondly, it would render the words "for personal profit" in Article 42 of the Convention entirely redundant. If they were to be read in to the term commercial activity, as the respondents contend they should be in Article 31(1)(c), then there would be no need for them to be present in Article 42 at all. And on that point of a presumption against surplusage, we've put in, and I hope it's on the desk before my lords and my lady just now, we've put in one additional authority over the short adjournment, the case of Ryanair, which seems to us to be the most recent articulation of the principles against surplusage. The facts of the case aren't relevant, but what we say are relevant and provide further support for our position are two passages in the judgment of Lord Justice Patten, summarising the approach to statutory interpretation, both as regards the presumption against surplusage and as regards the treatment of modern or new forms of activity within older statutory language. At paragraph 23, we have Lord Justice Patten drawing attention to what is described as a strong presumption against surplusage, with a citation of Lord Bridge.
Why would it be surplusage in any event? because the subject matter of these two provisions is different. What they've got in common is the use of the word commercial. But one is concerned with regulating the behaviour of diplomats by prohibiting certain kinds of activity, and the other with limiting the immunity of the state in respect of what they have done. Their immunity, but it belongs to the state.
My Lord, yes. The surplusage issue only arises if one seeks or one tests, we say, the proposition that the Article 42 description of commercial activity for personal profit is identical to the reference to commercial activity in Article 31(1)(c).
If that's what they meant, they would need to put it in twice.
Yes, and they haven't put it in twice. They've only put it in one. They could easily have used exactly the same terms in each article. So, 23 on the strong presumption against surplusage. So, Article 42 is intended to have a specific meaning by reference to its use of those words in a way that 31(1)(c) does not. And Article 38 on a slightly different point, with the citation of, paragraph 38 on a slightly different point, with the citation of Lord Bingham's speech in Quinterville. Again, there's a reference to surplusage not being lightly assumed in the introductory words before Lord Bingham's speech is quoted. Then we have Lord Bingham's speech, and at paragraph 9 we have his explanation and examples as to how statutes are to continue to speak. The statute is always speaking, and how a term used at one time has to be given a modern, up-to-date term later. And the obvious example given there is the evolving definition of cruel and unusual punishment, meaning one thing in 1689 and quite another thing in the 21st century. So too, we say, slavery in 1961, involvement in the slave trade, has to be given some sort of up-to-date modern meaning in 2017. And commercial activity, if we're right, the commercial activity would inevitably have extended to the slave trade in 1961, then modern slavery must be embraced in it today. The words, we say, consistent with the presumption against surplusage, the words for personal profit simply do not fall to be implied in to the term commercial or professional activity. If they did, then they wouldn't be needed in Article 42. And if that's right, then the absence of the words for personal profit in Article 31(1)(c) is significant. And we say that would also make sense from a policy perspective. To give one example as a variant on one that Mr. Justice Laws contemplated and as cited by the Court of Appeal in its judgment at paragraph 12, on the respondent's approach to the correct construction of these two provisions, a doctor with diplomatic status who provided medical services and did so negligently on a pro bono basis would not be capable of being sued by reference to Article 31(1)(c), because it would be impossible to say that he had entered into that activity for personal profit.
But the same applies to your argument about employment contracts, doesn't it? If you were to be right that commercial activity for 31(1)(c) includes employment contracts, certainly private domestic employment contracts, well then Article 42 does not outlaw them.
No, it doesn't.
And that would make sense, wouldn't it?
Yes, it does.
The same point you've just made, but in a slightly more closer to home context.
You're quite right, my lady, and it fits indeed with the scheme, in a way, of the Vienna Convention, which contemplates employment contracts. So, whichever way one addresses it, we say Article 42 presents no obstacle. The words used are different. They're talking about different things. And so, strictly, they should be given specific meanings to the terms used by them. If, contrary to that, the approach identified by Mr. Justice Laws in Prop End of giving the words exactly the same meaning is followed through, and an insistence on a requirement for personal profit is made out, then in the particular trafficking context of this case, it is made out.
Is it possible that the answer to my Lord Wilson's question is that the non-inclusion of Article 42 in the 1964 Act was so that such contracts were not illegal? I've just prompted that possibility by the way in which I put the previous one to you. It's not part of UK law, and therefore it couldn't be concluded that activities entered into in breach of the prohibition in Article 42 were ipso facto illegal.
Well, logically that would make sense, my lady. I can't say whether
You can't say that was the answer, no.
I can't say that was the answer.
Well, perhaps Sir Daniel will
And it's
know.
right, and we'll go to it in a moment, it's right that an interrelationship between Article 42 and Article 31(1)(c) is acknowledged in certain passages in the Travo. Now, there's an important prior question as to the legitimacy as an exercise of statutory interpretation or treaty interpretation of whether this is a case where the Travo can properly be relied upon. But it's important because the Court of Appeal did rely upon that I A, acknowledge that fact, and B, show you those passages in a moment. So that is context as informed by the other provisions of the treaty. We've got ordinary meaning first. We've dealt with that. We've got context as informed by the other provisions of the treaty, the first two stages of the Vienna Convention on the Law of Treaties interpretation exercise, both of them, again, yielding an answer favourable to Miss Reyes. And we then get on to object and purpose. And we've set out our core submissions on this at paragraph 74, 76 of the printed case.
Yes.
And it's also addressed in paragraphs 20 to 25 of the Court of Appeal's judgment. Those questions are addressed in those passages of the judgment. Now, as to this, Ms. Reyes has three principal points. The first is that the purpose of the treaty, as reflected in its recitals, is to promote sovereign equality and to ensure the efficient functions of diplomatic missions, or efficient discharge of the functions of diplomatic missions. And we've seen that in recitals 2 and 4. Neither purpose would be infringed by the interpretation she contends for. And that point is further illustrated by the direct overlap in recitals set out to the Vienna Convention on Consular Relations, that's A4 tab 51 MS 2278. The direct overlap between those recitals and the recitals in the Vienna Convention on Diplomatic Relations, and the accepted position in the case law, even in the United States, that the engagement of a servant for purely personal services would not be within official functions and need not attract immunity. That's our first core point on object and purpose. The second is that, as I've already pointed out, it cannot be said, given the presence of the exceptions in Article 31, that merely to assert any form of civil jurisdiction over a diplomat would be inconsistent with those purposes. And thirdly, on this issue of impact, it should also be recalled that a diplomat will, even if I am right, have immunity from giving evidence in proceedings pursuant to Article 31.2. A diplomatic agent is not obliged to give evidence as a witness, and will have a substantial degree of immunity from execution of judgments pursuant to Articles 22.3 and 31.3. And so against that background, we say, as I submitted this morning, there is a real risk of overstating the impact on diplomatic functions, which a finding in Ms. Reyes' favour would give rise to. Now, the Court of Appeal's approach and reasoning to this question of object and purpose focused instead on the travaux préparatoires to the Convention, as you've seen from paragraphs 20 to 25 of the judgment. And we submit that that approach was flawed for three reasons. Firstly, under Article 31, 1 of the Vienna Convention on the Law of Treaties that we looked at this morning, the text of the treaty and its recitals are the primary means for identifying the context, object and purpose of a disputed term. Recourse to the travaux is only intended to confirm the meaning resulting from ordinary interpretation, or if the application of Article 31 of the Treaty Convention gives a meaning which is ambiguous or obscure or manifestly absurd or unreasonable. And we say that the Article 31 VCLT exercise yields a perfectly clear meaning capable of extending to claims such as Ms. Reyes's. And that should be the end of the matter. So that's our first point, if one looks simply at the interpretative sequence under the Vienna Convention on the Law of Treaties. Secondly, as a matter of domestic authority in that context, recourse to the travaux is only permissible where it clearly and indisputably points to a definite legislative intention. That was the view expressed by Lord Wilberforce in Fothergill and Monarch Airlines. The reference is Bundle A1, Tab 4, MS 1098, on page 278B of Lord Wilberforce's speech. And it commanded the support of the majority of their lordships. And the third point, flowing from that, is that the travaux here do not indisputably point to a definite legislative intention of the kind contended for by the respondents. And in this regard, we make the 5 points we've set out at paragraph 75 of our printed case. And one preliminary point, which isn't set out there. Now, the preliminary point concerns the number of delegates whose views are cited compared with the numbers actually present.
What's the figure? What's the two figures?
I'm sorry, my Lord.
What are the two
figures? Well, my Lord, in support of the linkage between Article 31(1)(c) and Article 42, relied upon by the Court of Appeal, the Court of Appeal cited the views expressed by 3 delegates, delegate from Guatemala, Colombia, and delegate from Japan, across 2 meetings held on the 23rd of March and the 30th of March 1961. In circumstances where we also know from the travaux voting figures that at least at the second of those meetings there were some 65 delegates in attendance.
Some might say this shows the problem of referring to the travaux.
It does, my Lord, we say.
Yes.
Turning, and so that's on the first point of linkage between Article 31(1)(c).
So what?
I'm sorry, my Lord.
Well, so what?
Well, so it illustrates the sound policy reason for being reluctant to get into the travaux, both under the Vienna Convention on the Law of Treaties and on the Fothergill guidance.
I think you say, so what, about the fact that 3 delegates happen to have that view?
My Lord, yes. There's one...
Were there any contrary views expressed if we're going into this sort of area?
No, my Lord, save for one exchange which we debate the significance of.
Yes,
one delegate referred to the question of employment contracts, the Yugoslav delegate. And on our reading of what he said, he was quite enthusiastic about an express exception for employment contracts being brought in. And the way we read his observations was to say, I think an express exception should be brought in, but if necessary, I'm prepared to let the current trend that's underway take its course. And the rapporteur doesn't embrace his suggestion of including an express exception. He doesn't challenge the trend that's been asserted. And so on our side, we say, well, there we have at least a contemplation of an emergence and room for an undefined...
In my bones that this case isn't going to turn on this point.
I suspect it won't, my Lord. Perhaps that's why it's only a preliminary point and didn't find its way into our 5 core points in the printed case.
Well, we're in danger of getting bogged down on the preliminary point. I'm afraid it's because we're putting questions to you about it. Very well. No, not just as much my... So we come on to your...
Come on to our points.
Points that are in your... Yep.
Yes.
Of which the 4th, I note, has 4 sub-points. Yep.
Yeah. And so the first one was the Court of Appeal's citation of the intended target of the exception as revealed by the Travo, namely activities wholly inconsistent with the position of a diplomatic agent,
Yep.
and which would be likely to lead to the diplomatic agent being declared persona non grata.
Yep.
And this material is drawn not from the observations of a single delegate, but from the ILC's own commentary to an earlier draft of the treaty, and so perhaps deserves the closer scrutiny. Now, on that, we say, as you will anticipate, that it would not preclude a finding that entry into an employment contract whose elements met the definition of human trafficking recognised in international law should attract immunity. That would readily be capable of being characterised as conduct leading to a declaration that an individual was persona non grata. And indeed, that appears to be all but conceded by both the respondents and the Secretary of State in their submissions to the court. The references for that in the respondent's printed case at paragraphs 13 and 93.4, and the Secretary of State's printed case at paragraph 12. Now again, it would be very surprising, we say, if the delegates responsible for drafting the Vienna Convention had intended to exclude engagement in one particularly obnoxious trade, the slave trade, from the concept of commercial activity. And if that's right, then there should be no difficulty in including its modern-day equivalent. That's our first point, responding to the 1958 commentary. Secondly, in responding to the observations of the delegate from Venezuela that were referred to, if the test is, would the conduct readily merit the description of being detrimental to the dignity of the office, then again, no difficulty at all if we are in the territory of a claim related to trafficking. The third point is the one I've already addressed to some extent, the interrelationship between Article 42 and Article 31(1)(c), which is acknowledged, as I say, by 3 of the delegates in the Travo and by the Court of Appeal. It presents no barrier for the reasons I've submitted in my submissions in relation to Prop N. We have no difficulty with the idea that everything prohibited by Article 42 would fall within the exception. We simply say that the exception can and should go wider than that. And fourthly, and this is the point I was tying myself in knots on a moment ago, the only reference to employment contracts came in the exchanges involving the Yugoslav delegate that we have addressed at paragraph 75.4 of the printed case. And then the final, the fifth point on this is the one I've already made by reference to Trentex. All of this was going on at a time when the move from absolute immunity to restrictive immunity, by reference specifically to the context of commercial activity, was underway in the state immunity context. And it would be very odd, and we would respectfully submit jarring, to require an entirely different approach to be taken in the one as opposed to the other. So we say as a matter of principle, you don't really get to the Travo, because the Travo, once you look at them, don't meet the high hurdle that Lord Wilberforce and Fothergill identified that they had to clear. But even if you do, they don't stand in the way of Miss Reyes' case, particularly when it is put by reference to the trafficking context. I would acknowledge that if we didn't have the trafficking context, they might provide a more substantial answer to the pure employment contracts can fall within commercial activity, because if it's correct to read Article 31(1)(c) as relating only to conduct which would be detrimental to the dignity of the mission for the diplomat to engage in, then it would be difficult to say that in relation to an otherwise entirely untainted, unflawed employment relationship. But obviously we say this case is a claim related to trafficking, so even if we get into the Travo, they're no obstacle to us. So the position, once one gets to the end of the Vienna Convention on the Law of Treaties exercise, which was the only interpretive exercise accepted to be legitimate and appropriate by the Court of Appeal, is that it's all in our favour when properly addressed and analysed. And that conclusion, we say, is then only further reinforced once regard is had to the three additional potential interpretive sources, the common law presumptions, Section 3 of the Human Rights Act, and Section 2 of the European Communities Act. So turning next, if I may, then, to the common law principle, that statutes are to be interpreted in a way which does not place the United Kingdom in breach of its international obligations. The Court of Appeal held, by reference to the House of Lords' decision in Fothergill, that the common law principle was simply not relevant because of the international treaty context of the statute that was in issue, and the recourse to it was therefore inappropriate. That's paragraph 46. It also held in the same paragraph that neither Article 15.3 of the Anti-Trafficking Convention nor Article 6 of the Palermo Protocol would be breached anyway, as neither of them addressed diplomatic immunity. Now, Ms. Reyes submits that each element of that reasoning was flawed for the reasons we've set out at 77 through to 80 of our printed case. As to the first point, there is, we say, nothing in Fothergill to displace the common law presumption. That case, of course, was all concerned with the extent to which one could have regard to the Travo in construing an incorporating act at a time when one couldn't have regard in construing ordinary domestic legislation to Hansard. And the approach that Lord Diplock and others identified was that where one was dealing with an incorporating statute, one could only have regard to principles which could be characterized as being of general acceptation. That's Lord Diplock at page 282A. As he put it, the language of an international convention should be interpreted unconstrained by technical rules of English law or English legal precedent, but on broad principles of general acceptation. And and the reference is MS 1128 to 1129. Now, we say that the common law presumption that we rely upon here, founded upon compliance on the United Kingdom's part with its international law obligations, is a principle of general acceptation. It's really another way of articulating the principle of harmonious interpretation that we've already seen specifically reflected in the Vienna Convention on the Law of Treaties at Article 32. As to the second aspect of the Court of Appeal's reasoning, to the effect that Article 15.3 of the Anti-Trafficking Convention would not be breached anyway because that convention didn't address diplomatic immunity, we say that this court's decision in Haunger is again of particular relevance. Ms. Reyes contends that her case is at least as clear a case as Ms. Haunger's, because the constituent elements or indicators of her trafficking case are centre stage in her pleaded allegations. And she contends, by parity of reasoning, that to construe commercial activity so narrowly as to exclude her employment relationship with the respondents would leave the United Kingdom in breach of its obligations under Article 15.3 of the Anti-Trafficking Convention. And that is so for two reasons. Firstly, she must, for present purposes and on the basis of her allegations, be treated as a victim of trafficking. And secondly, Article 15.3 of the Anti-Trafficking Convention, which we have at tab 3 of Bundle 1, MS 1029, provides that each party shall provide in its internal law for the rights of victims to compensation from the perpetrators. The word "from the perpetrators" obviously of key importance for present purposes, because the result, if immunity is upheld in this case, is that there will be no means of obtaining compensation from the perpetrators of Ms. Reyes' trafficking. Now, as I say, the Court of Appeal dealt with this argument quite briefly at paragraph 46, saying the provisions of the Convention do not address diplomatic immunity, which is the specific subject matter of the 1961 Convention and the 1964 Act. But we say, with respect, that that presents no answer, because the Court of Appeal's interpretation of the undefined term in the 1964 Act leaves a category of victim without remedies against a category of perpetrators. And it's clear, we say, that Article 15.3 is a result-orientated obligation. And that result would be frustrated were the Court of Appeal's judgment to be allowed to stand. It's true that the Anti-Trafficking Convention does not expressly address diplomatic immunity, but it's also true that it doesn't exempt diplomats in terms. So that's the common law presumption. You get to a very similar destination when you apply Section 3 of the Human Rights Act. And this is the stage of the argument that we address at our printed case at paragraphs 82 to 113. And so far as interpretive principles are concerned, we rely here both upon Section 3 of the Human Rights Act and upon the guidance, the interpretive guidance provided by the Grand Chamber in the case of al-Dalumi and various other authorities, including Al-Jeddah. Now, we've quoted Section 3 of the Human Rights Act at paragraph 82, and the immediate and obvious point to make is that whatever mileage can be gleaned from Fothergill for the purposes of neutralising our submissions on the common law, Fothergill cannot oust the mandatory obligation imposed by Section 3 of the Human Rights Act. That is what Parliament requires when an exercise of interpretation of a piece of legislation is in issue before the courts. At paragraph 84, we have sought to summarise the European Court's jurisprudence on the interpretation of international instruments in support of the proposition that there is an obligation to construe ambiguous international measures in a manner which minimises interference with fundamental rights and is most in harmony with the Convention. Now, for all the reasons I've been submitting, there's no difficulty, we say, on the pure Vienna Convention on the Law of Treaties approach for Ms. Reyes. But even if I were only able to use the Vienna Convention on the Law of Treaties to fight the case to a state of standstill and ambiguity at that point, then it would be here that this principle of interpretation would come to my assistance. And the most recent of the cases that we rely upon is the Al-Dalumi case, one of the sanctions cases that Strasbourg has considered, which is at Bundle A, tab 10, Bundle A10, tab 107, MS 4049.
Thank you.
And this case concerned the confiscation of assets pursuant to a UN Security Council resolution. And the complaint of the applicant that the grounds of challenge to such confiscation were limited in Swiss law to questions of identity and ownership of assets, and permitted no basis at all, no challenge at all to the basis of the listing. So it was one of the cases where an individual was included on a UN list. That then triggered an obligation to freeze the assets owned by the individuals listed. And the only argument you could have, so it was said in Swiss law, was I'm not that individual, or those are not my assets. And you couldn't run the argument that you shouldn't have been listed at all in the first place. Now, the point of principle that we rely upon is addressed at paragraph 138 of judgment, MS 4115.
Yes.
Where a number of apparently contradictory instruments are simultaneously applicable, international case law and academic opinion endeavour to construe them in such a way as to coordinate their effects and avoid any opposition between them. Two diverging commitments must therefore be harmonised as far as possible.
That's a legitimate approach as applied to two instruments, one of which is regional and the other worldwide. I mean, on the face of it, if one's construing an international treaty, it must mean the same whether the person asking you to construe it is a national of whatever state. Implicit in this is a suggestion that it might mean something different as regards a member of the Council of Europe from what it means as regards anyone else.
My Lord, yes, and that is a legitimate and we say mandated approach by virtue of Section 3 of the Human Rights Act.
Right.
In fact, though, the tension, the potential tension which underlies my Lord's question is not as stark as it might be on the facts of this case for a variety of reasons. Firstly, the Palermo Protocol, which Saudi Arabia has signed up to, acknowledges that victims of trafficking should receive compensation. The only distinction in wording is that it's silent as to source, whereas Article 15.3 of the Anti-Trafficking Convention requires compensation from the perpetrators. Secondly, the chart of treaty undertakings and obligations that we've set out in that one-page note I handed up this morning shows that Saudi Arabia has no difficulty at all with the prohibition on trafficking and the prohibition on slavery, and has not done so even prior to its acceptance in 1981 of the Vienna Convention on Diplomatic Relations. So there is no lack of harmony, even if one takes the international approach and not the regional approach, in this case, my lord. And we respectfully submit that it's disharmony that's promoted by the respondents' submissions rather than ours. So that's our broad substantive point. And I mean, the references in the table speak for themselves to some extent, but we've got, albeit not a treaty, a statement of the international law position in the Universal Declaration of Human Rights in 1948, over 30 years before Saudi Arabia signs up to the Vienna Convention on Diplomatic Relations. We've got the Slavery Convention going back to 1973, so far as their acceptance of it is concerned. And we've got their acceptance in 2009 of the Arab Charter on Human Rights with its prohibitions on slavery and slavery-like practices. So it's certainly the case, we say, that there's no difficulty whatever if we're in potentially ambiguous territory once one looks at Article 31(1)(c). The harmonious interpretation, consistent with the widespread rejection of slavery and slavery-like practices, is the one that is favoured by Ms. Reyes' submissions.
It would be odd if the interpretation of the Vienna Convention on Diplomatic Relations was, as it were, to be drawn down by and driven by the states that hadn't signed up to an anti-trafficking convention.
My lord, yes, although in fairness to Saudi Arabia, they couldn't sign up to the Council of Europe.
I'm talking generally.
Generally, my lord, yes. And
I mean, Lord Sumption's lowest common denominator point
quite
is problematical, perhaps.
It is, we would respectfully submit. And there's the further point that I hope came across in one of the observations I made this morning, which is that the Vienna Convention on Diplomatic Relations expressly includes a dispute resolution mechanism. Now, the fact is Saudi Arabia has chosen not to sign up to that, and that's entirely within her sovereign power to do so. But it does show that the parties contemplated that different interpretations at the municipal level could follow from the conclusion of the treaty, as was also shown by the Empire of Iran case and the Aldona cases we looked at earlier. And so there's no problem with municipal courts grappling with these points. And in a way, it's a similar point also to one of the points that Lord Denning made in the Trentex case, was to the effect that to preclude municipal courts from an interpretive exercise would be to stifle the development of customary international law in circumstances where it's recognised that judicial decisions can inform the state of customary international law. And it makes sense that there is a harmonious interpretation principle, as we see both from Article 32 of the Vienna Convention and from the court's approach in Al-Dalimi at 138, which I was looking at, and then also at 139 to 40. If there isn't any inevitable need for a conflict, why create one? There isn't any inevitable need for a conflict here, because we know that all states abhor slavery. We know effectively all states, European or otherwise, recognise the entitlement of victims of trafficking to compensation. And we know that the term commercial activity is undefined. And a harmonious
interpretation. Whereabouts are we in your case?
We're at paragraph 82. That's 84 is where I've dealt with Al-Jeddah through to Al-Dalimi, my lord.
Is that the end of the Article 3 point? Section 3.
That's the end of the the general interpretive harmonious interpretation point. Article 4 is also important to the Section 3 point, and that begins at paragraph 86. And that's because, and the importance of that point is that we've got something harder edged now as a result of the European Court's approach to Article 4 than simply a harmonious interpretation argument, because we have not only the acknowledgement that Article 4 carries with it positive obligations, which we've already seen illustrated by the Haunger case from this court, we've got a specific acknowledgement from the European Court of Human Rights in a decision as recent as March this year, the Chowdhury case, that in determining the scope of the positive obligations owed by Article 4, reference should be made to Article 15 of the Trafficking Convention. And so we've got a clear, we say, hard edge point to the effect that the European Court, in the case of Chowdhury, which we've referred to there, is expressly saying that Article 15 of the Trafficking Convention, with its requirement for compensation from the perpetrators, is to be considered when determining the scope of positive obligations flowing from Article 4. Now, the Court of Appeal addressed these arguments at paragraph 62 to 64 of its judgment, and held that they didn't make any difference to the present appeal because, as they put it, none of them cast doubt on the correctness of the approach adopted in cases such as Jones and Saudi Arabia of upholding a well-established rule of international law unless it was required to yield to another rule of international law. Now, as we put it in our notes this morning on page 2, and this is the first, we respectfully submit, the first of the fundamental flaws in the way the respondents put their case and in the way the Court of Appeal approached the case. In Jones, it had to be accepted that there was a well-established rule of international law provided for in what were described as plain and unequivocal terms in the domestic statute, that states and their agents had immunity in respect of tort claims arising out of events occurring out of the jurisdiction. And in this case, the starting point is fundamentally different. It is not accepted that there is a well-established rule of international law, that diplomats are entitled to an immunity which we are seeking to displace. On the contrary, what we are seeking to do is to construe an accepted but undefined exception to immunity. And so just as the European Court, by way of example, Al-Dalumi, required construction of an ambiguous United Nations Security Council resolution and obligation in a manner which involved the least interference with fundamental rights, so too, we say, it's appropriate to construe an ambiguous obligation, assuming that to be the case, under the Vienna Convention of Diplomatic Relations in the same way. And the respondents can't gain anything either from the fact that the Anti-Trafficking Convention was signed by the United Kingdom after the Vienna Convention on Diplomatic Relations. The Vienna Convention on Diplomatic Relations was ratified in 1964, 13 years after the United Kingdom had ratified the European Convention on Human Rights, and 16 years, of course, after the broad prohibition on slavery and slavery-like practices reflected in the UN Declaration. had been promulgated. And if one looks briefly at that table, if I may, my Lord, of what we've described as treaty ratifications, albeit also including the UN Declaration, for the purposes of weighing up this harmonious interpretation point, or Section 3 interpretation point, however one puts it, you get, we say, 4 key points from this. The first is that prior to Saudi Arabia signing up to the Vienna Convention on Diplomatic Relations, she had signed up to no less than 4 conventions aimed at the abolition or suppression of slavery or forced labour. Secondly, prior to the conclusion of the Vienna Convention on Diplomatic Relations, the Slavery Convention had been in existence for almost 40 years. Thirdly, as I've just submitted, prior to the United Kingdom's entry into the Vienna Convention on Diplomatic Relations, the United Kingdom had signed up to the European Convention on Human Rights. And fourthly, the Kingdom of Saudi Arabia, through its acceptance of the Palermo Protocol in 2007, has explicitly recognized on the international plane that states are obliged to ensure that their domestic legal systems contain measures which offer victims of trafficking the possibility of obtaining compensation. Now, we then set out, and it may not be necessary to go through this in a great deal of detail, but we've then set out at paragraphs 86 and following, as I say, the particular provisions of the European Convention on Human Rights that we rely upon, Articles 4, Article 6, and Article 13. Article 4 first, the most obvious one in play, the prohibition on slavery and slavery-like practices. It's 86 to 103 of our printed case. And we make 3 points on this. First, Article 4, as now interpreted, embraces a right to freedom from human trafficking. We get that from the Rantsev case. It may be, we should just look very briefly at Rantsev. It's tab 13.
You set it out in your case, haven't you?
Yes, my Lord. I just wanted to show you, if I could, paragraph 281, which we didn't quote. Tab 13, MS 1438 of Bundle 2. I just wanted to emphasise, I mentioned it in passing this morning, but I just wanted to emphasise the words that the Court uses at the beginning of paragraph 281 to further support the case and explain why so many states around the world, including the United Kingdom, describe trafficking as a form of modern slavery.
Could you give me the page reference to paragraph 281?
Yes, my lady, it's MS 1499.
1499.
MS 1499, yes. The Court considers that trafficking in human beings, by its very nature and aim of exploitation, is based on the exercise of powers attaching to the right of ownership. It treats human beings as commodities to be bought and sold and put to forced labour, often for little or no payment, usually in the sex industry, but also elsewhere. And that reference to based on the exercise of powers attaching to the right of ownership provides a direct bridge and link to the definition of slavery articulated as long ago as 1926 in the 1926 Convention. So far as the broader point that we've already made in our submissions at 87 by reference to 282 of Rantsev is concerned, it's also the case that the Arab Charter signed up to by Saudi Arabia also expressly refers to a prohibition on trafficking. It's Article 10, and the reference is MS 2366. So there really shouldn't and can't be any controversy over the fact that Article 4 embraces a right to freedom from human trafficking. There can't be any controversy about the fact, see Haunger and other cases, that it carries with it positive obligations imposed upon the state to protect victims of trafficking. And we now know, as I've just been submitting, that the extent of those positive obligations falls to be determined by reference to the Council of Europe's own anti-trafficking convention, including in particular Article 15.3 of the convention and the entitlement of victims to claim compensation from perpetrators. And we get that from the very recent decision of Chowdhury from the European Court, which is at A2, tab 14, MS 1515, handed down in French on the 30th of March 2017, and thanks to the industry of those behind me, we have an official translation in the bundle. Misplaced my Now, Chowdhury concerns some pretty extreme facts and different facts to ours, and it concerned a criminal prosecution for human trafficking brought against alleged traffickers, which had resulted in an acquittal. And the alleged victims contended that the court had misinterpreted the domestic law relating to trafficking. The prosecutor refused, despite that, to appeal, as was within his power under the relevant law in Greece. And the particularly relevant passages we rely upon are in paragraphs 103, 104, and 126 to 128. And we have from those passages, it put beyond doubt that in determining the extent of a state's positive obligations under Article 4, specific regard is to be had to the terms of the Anti-Trafficking Convention. So we get a reference at 104 to the question of positive obligations and to that convention. And we get then from 126 and 127, again, a further reference to Article 15 specifically of the Council of Europe Convention on Trafficking, and the ultimate obligation to ensure an effective investigation and judicial procedure, none of which would be achieved if, in this case, immunity were granted. Now, the Court of Appeal, of course, didn't have the benefit of Chowdhury when it was considering Ms. Reyes' case, but it addressed the question of Article 4 and Section 3 of the Human Rights Act as distinct from the question of harmonious interpretation in paragraphs 52 to 60 of its judgment. And it again did so by reference to the approach taken in Jones and the suggestion that it was said that it followed that in order to invoke Article 4 at all, Ms. Reyes would have to show a superior rule of international law entailing an exception to diplomatic immunity. Now, as I've submitted, that is not what we say the exercise before this court is actually about. The same issues arise out of Article 6 and Article 13. There is in addition, in relation to Article 6, the question as to whether Article 6 is engaged. And as the court knows, that is a thorny issue which has gone back and forth with Holland and Lamp and Wolf and Jones and other cases, and is also in play in the Ben Kabouche appeal, which I understand, in fact, this panel is hearing in a few weeks' time. Our submissions on this, and I don't want to take undue time on it orally, are set out at paragraphs 104 through to 113, both in terms of engagement and application of Article 6. So far as engagement is concerned, the position we say is quite simple. Whatever one thinks of the merits of the approach that's been taken in Strasbourg as compared with the merits of the approach first articulated by Lord Millett in Holland and Lamp and Wolf, the fact is that there is now a consistent line of Strasbourg case law, including at the Grand Chamber level, to the effect that Article 6 is engaged in cases concerned with state immunity, by characterising it as a procedural immunity from suit in respect of an otherwise valid claim. And the court, we therefore say, should follow that approach, having regard to the principles identified in Chester. And we respectfully submit some support in that regard from the observations that my Lord Sumption and my Lady Baroness Hale made in respectively the Belhaj case and the Serdar Mohammed case that we've referred to at subparagraph 6 on page 171 of our printed case. Again, we say, in terms of the substance, once Article 6 is engaged, the Court of Appeal simply took the wrong approach in analysing how it applied. The Court of Appeal took the approach, quite understandably, that once Article 6 was engaged on the Strasbourg authorities in an immunity context, the key question that arose was whether an immunity was required, the grant of immunity was required by international law. If it was, then because Article 6 was a qualified right, and the right of access to court was not absolute, then that would be a proportionate and legitimate response to a legitimate aim. But our argument is a quite different one. We say, as I've been submitting, that the extent of the obligation imposed by the Vienna Convention on Diplomatic Relations, and more specifically by the Diplomatic Privileges Act of 1964, is undefined and ambiguous, and so it falls to be construed by reference to Article 6 along Al-Dalumi lines. And it's for that reason that we don't get anywhere near, we say, needing to seek a declaration of incompatibility or anything of that kind. Now, it's said against me in that regard, oh, well, for your interpretation to be correct would radically alter the scheme of the Vienna Convention on Diplomatic Relations so as to breach the interpretive obligation limits set down in Gaydan and other cases. It would change the substance of the article completely. Well, we submit, of course, for the reasons I've been trying to articulate today, it would have no such radical effect at all. All it would do would be to bring some clarity to an undefined term in a manner that would be consistent with the related branch of state immunity. It would leave in place, if one confined the outcome in the case to the trafficking context, it would leave in place a requirement for personal profit and a satisfaction of that requirement. And it would leave in place a requirement, if one allowed recourse to the Travo, for the conduct to be properly characterised as being contrary to the dignity of the mission and of a kind which could lead to a persona non grata declaration. So far from changing the substance of the article or running counter in some way to the overall scheme, it would be entirely consistent with it. Now, EU law analytically leads to the same outcome. It doesn't add anything in terms of substantive argument. And so in one sense, if I'm right so far, I don't need EU law. And if I'm wrong so far, it won't save me. But it's another illustration of the only other interpretive tool pointing to the same conclusion, we say. Now that leaves only, for the purposes of my appeal, the fourth stage and the question of official functions. And so far as this is concerned, our submissions are at paragraphs 114 to 123 of the printed case. And the position here is, we say, particularly striking in circumstances where the Court of Appeal's approach has led to a result which is unsupported by any previous authority, including that cited to the court in this case and not addressed in the Court of Appeal's judgment. But before looking at that case law, I'd like to emphasize some points from the factual context, if I may. The first is that the contractual relationship here was between Miss Reyes and both respondents. And there could, of course, be no question of the second respondent, Mrs. Malki, discharging any official functions at all in her engagement of her. The second is that the payment for Miss Reyes was to be by the respondents. The payment to Miss Reyes was to be by the respondents. The third is that her work was exclusively at the respondent's domestic residence. And the fourth is that her work was of a purely domestic nature, consisting of cleaning, cooking, and childcare, and involved, for example, no role whatever, even in the provision of what might otherwise be characterized as some form of official entertainment at the diplomat's residence, in terms of dinners or receptions and so forth.
Whereabouts are we in your case now?
You're at paragraphs 114 and following, my lord. So far as the factual background that I've just been identifying is concerned, you get all of that, I think, correct if I'm wrong, from the statement of facts and issues.
Yeah.
And none of it's contested. So even without the trafficking element, all of that very strongly suggests that this relationship was not concerned with official functions at all. If one then adds in to the debate the trafficking context and all previous domestic and comparative case law, then the conclusion that this relationship was outside official functions, we say, becomes completely irresistible. Now, the Court of Appeal's reasoning on this issue was quite briefly stated, and it's first at paragraph 19, with the assertion that employment of individuals to provide domestic services in a diplomatic mission or an official diplomatic residence in the receiving state is conducive to the performance of diplomatic functions. And secondly, at paragraph 29, in the last three lines, where it said the employment of a domestic servant at a mission is an activity which is incidental to the daily life of a diplomatic agent and enables him to perform his official functions. Now, there are similar statements made in paragraphs 13, 14, and 16, but we respectfully submit they don't add anything of substance to what in the end boils down to an assertion that we are wrong. And there are at least two problems with the approach the Court of Appeal took, we say. The The first is a narrow factual one, in a sense, that responds to paragraph 29. This appellant was not employed at a mission at all. And it's hard to see how the relationship with Miss Reyes was conducive to the first respondent's performance of his diplomatic functions, or enabled him to perform them. And the second, more substantive problem, perhaps, is that the court entirely failed to address such authority as was before it on this issue, and which Miss Reyes says there is no reason to depart from. Now, that authority consisted of 3 decisions from this jurisdiction at first instance, and 3 appellate decisions from the United States of America. From this jurisdiction, there were the views of both the Employment Tribunal and the Employment Appeal Tribunal in these very proceedings, each of which on this point had favoured Miss Reyes, but went unaddressed by the Court of Appeal. There is a further High Court decision, and there is a further Employment Appeal Tribunal decision. And from the United States of America, there is the case of Park and Shin, the consular immunity case that we already looked at this morning, and at least 2 further authorities which are themselves cited in the English case law. Now, all of this can be taken perhaps most conveniently from Mr. Justice Langstaff's decision as the President of the Employment Appeal Tribunal in these proceedings, which the Court has at Core Volume 2,
Thank you.
MS 639. And it's paragraph 9 through to 20 that deal with this. So we have at paragraph 9 on MS 643 a description of the Employment Tribunal's conclusion. And for the Court's reference, the Employment Tribunal decision itself is at MS 657.
Thank you.
And the Employment Tribunal judge's view was that Article 3 of the Vienna Convention, with its list of official functions, provided some insight as to a diplomat's role. And the words official functions should not be extended to cover what the Employment Tribunal judge, we say rightly, characterised as purely private arrangements. At paragraphs 10 through to 13, Mr. Justice Langstaff addressed some of the other Vienna Convention provisions relied upon by the respondents and some of the other authorities relied upon by them. In particular, there was reference to Article 10, I think, of the Vienna Convention that I've already referred to, and the potential for the recognition that diplomats might engage personal servants, and the reference to some academic commentary, yes, which had referred to that, Sato. And then at paragraph 14, the judge concluded that that was to conflate what a diplomat might normally be expected to do in a jurisdiction with what was properly characterised as being within his official functions. At paragraphs 15 through to 17, the judge then described the 2 other first instance decisions I've referred to, of Wakori and Abu Sabib, both of them relating to residual immunity issues and the meaning to apply to Article 39 of the Vienna Convention, but providing valuable assistance on the meaning of official functions for the purposes of Article 31. And we see at paragraph 15 in particular a citation of Mr. Justice Newey's decision,
Yes.
and his own citation of the support he derived from various American decisions, Bowen and Swana in particular. And then at paragraph 19, we get the spectrum referred to that I mentioned when answering my Lord Sumption on a question this morning. And This is drawn from an earlier decision which again had involved Mr. Justice Langstaff, Abu Sabib, and as he put it there, the appeal tribunal envisaged a spectrum. In principle, the employment by a diplomat of another to provide personal service to him whilst engaged in the mission might be regarded as a function of the mission, since it could be ancillary to important functions, better enabling a diplomat to attend to his central role. The employment of a domestic worker who performed no task outside the diplomat's home had so little connection with the functions of the diplomat's mission, which had to be regarded as closely related or ancillary to those in Article 3, that it would fall at the end of the spectrum, which was outside the proper scope of official functions. And it followed that the act of employing such a person was unlikely to be an act performed in the exercise of the functions as such. Yeah. And he carries on with a clear distinction between that case and a different case. And we respectfully submit that there is very considerable force in those submissions, those observations of Mr. Justice Langstaff and the reasoning of it and the common sense underpinning it. And it chimes closely with the remoteness point that my Lord Sumption made in questioning me this morning. And with respect, it's not engaged with adequately or at all by the Court of Appeal, which failed to address any of these cases, let alone the reasoning articulated in them. So here we say the correct conclusion should be that not all employment of private servants should be held to be within official functions. Relevant questions will include when the relationship was entered into, what the nature of the work to be performed was, whether it touched upon official functions, and who was to pay for it. Those were all, as we saw from the El Haddad case on state immunity earlier this morning, the kind of questions that were required to be reconsidered on remission. And posing those questions, and on that analysis, it inexorably follows, we say, that Miss Reyes' work was correctly characterised by the employment tribunal judge as relating to purely private arrangements.
Could you just give us the precise reference to the facts? We have the employment tribunal at page 658.
Yes.
And is this where the primary facts are then contained?
It is, my Lord. We have also the statement of case, which is at page 680. The statement of claim, I should say, page 680. And I just want to see if the statement of facts and issues deals with this sufficiently.
Is this case being proceeded on the basis that the allegations in the statement of claim are true?
Yes.
It is.
It is, and that's, we say, the correct approach.
Well, I'm not saying it's not correct approach. I'm just trying to find out
Yes.
precisely what the clearest statement of it is.
Yes.
Now, are the averments in the statement of claim the same or different from the facts referred to by the employment tribunal from paragraph 5 onwards?
They should be the same because the respondents had invited the employment judge to proceed on the basis that the allegations were true.
My Lord, if I can help you, that's not the case, but I will address that.
Maybe you could just tell us now where we'd find the facts then, if they're not there.
I think Mr. Otti is going to point you to where the facts are.
Right.
In their stated case, they've referenced the fact that before the employment tribunal with the written counsel, there was an invitation or an acceptance that the employment tribunal could proceed on the basis that there was an assumption that the facts were true. In the case both before the Court of Appeal and in our written case, I don't have any references immediately to hand I can provide them. We've gone back on that. We don't think it's the correct approach to proceed on the basis that the claimed facts are true.
Okay, so where would I find, if I wanted to look at where the facts were set out between now and tomorrow morning, where would I look?
Yes, I mean, I'm sorry.
Well, they're pretty critical of facts, aren't they? As in every case.
Yes, they are. Now, I didn't understand that any of those facts that I started this section of my submissions with to be controversial. namely who employed Miss Reyes, who paid for her, where she worked, what the nature of her work was.
But really, in answer to Lord Clerk, it's the statement of claim from 680 onwards and your client's witness statement from 781 onwards, isn't it, Mr. Ottey?
Thank you very much, my Lord. And I certainly didn't intend to represent to the court that Mr. Bethlehem was conceding that you should proceed on the basis that all the facts were as we alleged. He doesn't. He seems to say that because no factual findings are made, it's impossible to consider these allegations. We say it's entirely conventional, see Jones, see the United States cases, for the court to proceed on the basis of allegations for the purposes of testing an immunity argument. Otherwise, it would be open to a state or a diplomat in any case to simply respond to a factual matrix said to give rise to an exception or satisfaction of exception. We don't admit those facts. End of the case.
I mean, what is obviously awkward, you've got the clear concession of learned counsel then representing the respondents in paragraph 5 of the employment judge's judgment at 658 as has been conceded. That was then conceded, and if it hadn't then been conceded, you might have found the employment tribunal going and deciding, well, we better deal with the facts then, which puts us in an awkward position.
Exactly so, my Lord. And it's not, we've addressed this issue of fact-finding and the obstacle that it's said to present in our written case. Now, this is jumping back from the specific issue of official functions, but the points we make in this regard are important, we say, and valid here too. And I think it's paragraph 65 of our printed case, where we say that the fact that we're dealing with allegations only at the moment and not with a conceded factual landscape can present no obstacle to the proper grappling with an immunity case. We've given a whole series of examples of how courts would grapple in the context of state immunity.
Examples is one thing. I'm interested in what the assumed facts are to be. It appears to me that what we should do is when we come, we want to state the assumed facts upon which we're proceeding and move on from there.
My Lord, yes. Well, I think for those
In my mind, that's a very important aspect of the case.
For those purposes, I think it's right to say that A, there have not been factual findings, and B, you have...
There are 1,000 cases where there haven't been factual findings, in which case you have to assume the facts.
Yes, and we say that the correct approach is to assume the facts as alleged by the claimant, because by definition in an immunity case you don't have a defence. Now,
Well, your case is that the facts are as pleaded
yes,
for the purpose, or assumed to be as pleaded for the purpose of the present exercise.
yes,
And that's your answer to Lord Clerk.
and that's my
They had to
answer.
be found, presumably, in the point of claim.
Yes,
Yeah, fine. Okay, thank you.
and if at the end of this process, if we're right on immunity so far, and the case goes back down to an employment tribunal, and our factual case turned out to be a complete fantasy, then immunity, not only would we lose on the merits, but we would lose on immunity too.
Difficulty would come if some of your facts were accepted and others weren't. Then have to go through this all over again, presumably,
Well, it would depend
depending on what the
and
findings
what the
were.
facts were and
Yes.
what the court's, the breadth of the court's
course, of
reasoning
course
was.
it
If
would.
the,
Yes,
if the court went for the more far-reaching,
All right, let's say there'd be a risk that the court would
Yes.
have to go through it all over again. Yeah, okay.
but in circumstances where there's
One of the classic risks of any
Preliminary point.
preliminary point.
exactly so.
You can't really win. Either you don't have a preliminary point and they say, why didn't you have a preliminary point? Or you do and they say, why did you have a preliminary point?
Yes. And one at least has the comfort in this context that the competent body established by the United Kingdom for the purposes of compliance with the Anti-Trafficking Convention and monitoring the United Kingdom's obligations in the trafficking sphere has concluded that Ms. Reyes is a victim of trafficking.
Yes.
So we are not in outlandish, fanciful territory, at the least. We've got a reasonable prospect, on any view, of establishing that.
The Court of Appeal doesn't seem to have dealt with the factual basis on which they proceeded in any express detail.
No, because it took the approach correctly, we say, of looking at what was pleaded.
Quite.
And it took the approach, consistent with its acceptance of our stage 2 of our submissions, that this claim was related to trafficking.
Quite.
By virtue of the fact that we'd pleaded the 10 indicators of trafficking. And that, we say, is analytically the correct approach. And I'll find the reference overnight, if I may. It eludes me at the moment, but there's, again, to the extent it's useful to draw upon comparative law in this context, the approach taken in the United States is to, on immunity questions of this kind, is to assume the allegations made to be true and to permit all reasonable inferences from them for the purposes of the argument. And that's sufficient and for my purposes, and we say correct as a matter of principle.
Presumably it's got, if you're right, it's not to be an absolute rule that whatever's pleaded is assumed to be right. There's got to be a limit to that. Presumably the court can inquire in appropriate circumstances to some extent.
Yes.
But as a general proposition,
Yes.
Unless there are good reasons to be very sceptical about what's pleaded, you proceed on the basis of what's pleaded. That's
Exactly
okay.
so, Malki.
Okay.
I would certainly accept it would be open to a diplomat or to a state who faced an allegation that was completely wild and fanciful
Yeah, I see.
to come to the court and say, we have immunity, and for the purposes of establishing our immunity, we want to strike out these factual allegations.
Okay.
Of course, the UKVI conclusions that this was a trafficking case were almost entirely based on your client's evidence, but I think not entirely, because I think, correct me if I'm wrong, Mr. Otti, there was evidence that the policeman had to go back with your client to the house and get the passport from the respondent.
That's absolutely correct, my lord. Yes.
Very well.
I have to go back to my house to get a passport from my wife. Yeah.
If the court wants to look at what insight we do have into the respondent's response on the facts,
Very briefly, just take us.
I'll give you the references, if I may, and let
Very
Sir
briefly,
Daniel.
give us the pages. Yeah.
It's pages 212 to 213 of the core volume, I think,
Right.
left
Thank you.
from the Malki solicitors. But I'd
Well, you may want to say a bit more about it, depending on where we get to it with Sir Daniel. And obviously, if you say a bit more and he wants to come back, we can deal with it then. But
I'd like to proceed with it in that way, if I may. And so that,
yeah,
I think, that takes me, my lord, sorry. Yes, that takes me to almost the conclusion of my submissions on the appeal, with one additional point only.
Yep.
And the additional point only is that we've set out in our printed case, I think it's paragraph 120.
yep,
3.
right.
Sorry, I may have the wrong one. Yes,
Is it-
1, 2, 3.
Yep.
If we were
Page
right
1 and 2,
only
yeah.
on our second ground of appeal, official functions,
Yep,
but wrong on commercial activity,
yep,
then in circumstances where the Malkis have now left the jurisdiction, then we would say they have no residual immunity by reference to Article 39
yes, I see.
of the Convention. And so there should be a remission. Now, the issue between us there is that Sir Daniel says it's too late to raise that point,
Yeah.
and if immunity was valid at the time the claim was issued, then there's no power for remission in any event.
Right.
And as to that, we say that there's quite long-standing authority from Court of Appeal, at least in the case of Empson and Smith, that we've referred to, indicating that provided immunity has gone prior to a claim being formally struck out, then there is no obstacle to it continuing. And in this case, there has yet to be an order formally striking out the claimant's claim.
Yes, I see.
So if we're right on only official functions, then we still say there should be remission. But obviously, as I'm sure you have picked up, we say we're right on both points.
I think we will have
and
that.
resoundingly so. That's slightly quicker than anticipated.
We don't have to apologise.
Intending to say on our appeal, unless there are further.
No, well, thank you very much. There's never need to apologise for being shorter than you budgeted for. Thank you. Thank you, Mr. Otti. Mr. Luckhurst. Thank you very much. Sir Daniel.
My Lords, my Lady, we were anticipating coming on tomorrow just before the lunch break. So Mr. Otti's extra 15 minutes presents a little bit of a conundrum as to what we should...
If it's a serious problem, I don't think we'd want to embarrass you by requiring you to proceed, but if you are in a position to proceed, we'd be grateful.
My Lord, thank you. It's not a serious problem. I think there are some submissions that can be made briefly in these 15 minutes. I think that what it does mean, though, in reference to, my Lord, your observations that the court would rise at 3 o'clock tomorrow, I think I'm safe in saying, looking at Mr. Otti and Mr. Luckhurst and also at Mr. Swaroop, that we would not be requiring to go into the additional day as we've...
That's a very helpful indication. It's encouraging, but we won't hold you to it.
Thank you.
We hope that it turns out to be right.
Thank you, my Lord. My Lord, I appear with Mr. Swaroop representing the respondents, Mr. and Mrs. Al-Malki. I should make it clear at the outset, because it goes to some of the issues that have been addressed today, that it is Saudi Arabia that is asserting the immunity of the Al-Malkis. It's the Al-Malkis who are the respondents, but the immunity is, as it were, owned by Saudi Arabia. I will come back most certainly tomorrow morning on the question of waiver and going to my Lord Sumption's questions. In fact, we consider that the provisions on waiver in Article 31, Article 32, are in fact in favour of the respondent's case rather than the appellant's case. But as I say, I'll return to those tomorrow. Just to give you a sense of how we are going to divide the case between us, I will, for the remainder of the day, for the 11 minutes that are left, begin on the issue of the interpretation of the Vienna Convention on diplomatic relations, and we'll deal with Mr. Otti's case on ambiguity, or as we would put it, on clarity. Mr. Swaroop will follow me. I anticipate that it will be tomorrow afternoon. And he will pick up on the allegations of trafficking and the intersection of the allegations of trafficking and the European Convention on Human Rights issues. So that includes also the Anti-Trafficking Convention and the intersection of those issues with the Vienna Convention. He will also deal with some remaining issues relating to the jurisdiction of the Employment Tribunal. I will then return thereafter to address the respondents' cross-appeal on the issues of service. So that's very broadly the roadmap.
Thank you.
Perhaps just one other small housekeeping point, and I understand that this is not going to be a point of difference between Mr. Otti and myself, having in mind the formality of Rule 47 of the Supreme Court rules, we would wish to defer making any submissions on costs until after the judgment is rendered. And
there is a certain disconnect between the rule and practice on that point. And we're happy to go along with the practice, normal practice.
Thank you very much. Just a clear...
perfectly proper to raise it. Thank you.
My Lords, my Lady, I will, if I may, tomorrow morning, simply because it will give me an opportunity to reflect on the exchange that brought Mr. Otti's proceedings to a close on the acceptance of fact. I will come back to that briefly tomorrow morning, but perhaps I should simply say at this stage, in case it assists, that our concern with the acceptance of fact is that it puts the issue of when immunity is to be addressed to one side. And as you will hear both from me and from Mr. Swaroop, we consider that the issue of immunity is an issue that has to be addressed in limine right at the outset, and we don't think that that was done by the Employment Tribunal. So the case proceeded on the basis that there should be an assumption of the facts that were pleaded. Now, it may be that a logical conundrum, as was evident in the submissions and the exchanges, the submissions of Mr. Otti and the exchanges, the logical conundrum can be addressed by saying, assuming at its highest the claimant's case against us, this is the way that we would meet it. But what we do not want to concede is any of the facts, the detail of the facts that are alleged. Now, this said, there will be, as there has been with Mr. Otti, one aspect of the facts that I too will come to tomorrow morning, which we believe does have relevance to the issues before you. One other preliminary issue just to address, which is where Mr. Otti closed, is that Mr. Otti and Mr. Luckhurst, or the appellant, has sought to keep open the possibility that there is a live residual issue under Article 39, paragraph 2 of the Vienna Convention. And they do so on the ground in their written case that it may be of significance to the correct disposal of the appeal. And the reference for that assertion is MS 182 at paragraph 122.
Yes.
We object to that attempt to keep residual immunity as a live issue, even if it's only as a live issue on remission back to the Employment Tribunal. Residual immunity was not addressed before the Court of Appeal. It was not in the judgment of the Court of Appeal. It was not identified in the appellant's issues for determination in the statement of facts and issues. And indeed, there was an application for permission to intervene in these proceedings by A4 Law, which was refused. Now, that application for permission to intervene was stated to be directly in order to inform the court about the issue of residual immunity. We, the respondents, objected to that application for permission to intervene, and the court denied that application to intervene. We consider that this is unwarranted, out of time, and not part of the grounds for appeal. It is something which, if you were minded to invite further argument on, I would be happy to develop further, both as to the formality of the, if I can put it this way, the late application, but also on the detail of it. But I don't otherwise propose to address the residual immunity under Article 39(2) any further.
Well, what you're saying, just so we're clear, is that you object to this. If we accept your objection, fine. If we think that we want to decide it and there's something in it, then you're saying you'd like to provide us with a written argument about it, or what?
My Lord, I think that there are a number of as it were, sort of variables. We object to the appellant's attempt to keep an Article 39(2) case alive. Were the court in these proceedings minded to address Article 39(2) further,
yes,
then I think that you would have to invite further submissions, both because Mr. Otti hasn't set out his case on Article 39, paragraph 2, apart from referring to it in passing. and because we haven't had an opportunity to meet it. If, however, you were minded simply to refer the matter back to the Employment Tribunal, I think that there would be a suite of other arguments that we would want to raise, including as relating to issues of timing, relating to the jurisdiction of the...
What you're saying is we should shut it out. That's your primary position.
Yes.
If we're against you on that, would you say that we should deal with it or send it back? I'm not saying we are against you, but I just want to know exactly where you stand.
My Lord, with the latitude, I hope to be able to come back on this issue overnight. I think my...
If you'd like to do that, and leave open the answer to my question.
My initial submission to you would be, if you were minded to do so, our inclination would be that you should do so rather than remit it back.
Thank you.
This is an issue of some complexity and some novelty, and we would find ourselves back before you in 2 or 3 years' time otherwise.
Well, that does seem to be quite a good argument for us dealing with it if we decide that it's open to Mr. Ottey to have it dealt with, but we'll wait and see.
Thank you. My Lord, Mr. Ottey has been very helpful in the clarity that he's brought to his submissions in making it plain that this is a case about the interpretation of Article 31(1)(c), and the difference between us is quite clear. He contends that the provision is ambiguous and should be read expansively by reference to trafficking principles and beyond. We say Article 31(1)(c) is clear, and that it creates a clear and binding treaty obligation.
I'm not sure that Mr. Ottey says it's ambiguous. He says it means one thing, you say it means a different thing.
Well, my lady, I stand corrected. I think he said that it's clear in his favour. He then said if it's ambiguous, he then has a second.
The case is that it's clear in his favour.
Yes, I accept. I'm happy to accept that correction. And I will, I think, come to this more fully tomorrow morning. We take issue with the vantage point that Mr. Ottey brings to the case with his 4 stages. We think that they set about it in the wrong way, and that the first issue that needs to be considered is the interpretation of Article 31(1)(c), its ordinary meaning in the context of the treaty as a whole, and in the light of the treaty's object and purpose, rather than infusing the exercise right at the outset with a question of whether trafficking requires the provision to be read in a particular way. My lords, my lady, there are a number of baseline propositions that I would like to make. I see that we are almost at 4 o'clock.
Are you saying you'd like to make them at 10:30 tomorrow?
I think that's my application, my request.
Well, in that case, we'll accede to it. And
Thank you very much.
Mr. Ottey, you wanted to say
Just
something?
use the 1 minute to clarify. I wasn't quite sure where we ended up on what documents were missing from the court in terms of the documents which had come in after the bound.
I'm not
volumes.
entirely...
We found everything.
You found everything. I'm
Yes.
grateful. And did my Lord Sumption find, in particular, our note of reply on the cross appeal?
Yes.
I'm grateful in that case. We don't need to bring anything further. Thank you.
Okay, right. Well, thanks very much indeed. Then we will resume again at 10:30 tomorrow. Meanwhile, the court's adjourned.